Are you there? Sanjeev? Sanjeev, can you hear me?
I can hear you
No, he's
loud
not
and
here.
clear, but I understand that
Okay.
Google Meet creates a problem. So in Google Meet, my audio goes away. I don't know why.
Okay, then we'll organize something else then from next time.
That's fine. We'll do it. I'm doing from other system. That's perfect with me. There's no harm. But the only thing was, as I said, in Google Meet, this issue I am facing. So we'll find a solution to it. Don't worry. I'll call the technicians tomorrow to look at it. Kya karna hai, sir? But otherwise, we can start.
Yes, we welcome you all. Means we all welcome you, and we request you to kindly start.
Yes, Rajesh, it's always a pleasure to be with you. You are making me also work.
We do acknowledge the hard work that you are doing for all of us. In fact, for the young generation, no.
Yes.
For the younger generation, many of whom are newly enrolled lawyers and many of whom are students. And they are very excited because such opportunities are not very easily available in Jharkhand. And therefore, it's a great service that you are providing.
It's not this service. I will not, put myself on such level or pedestal. But yes, if I can do something and they benefit out of it, I'll be really happy.
Yes.
And it gives a lot of satisfaction.
I hope you people are benefiting. I hope you people.
Yes, sir.
Yes, sir.
Yes, sir.
Yes. Because I'm seeing that people who attend one class generally attend the next one, except for fee. So the newcomers are less and less, and the old people continue in the class. And because of the gate crash, I try not to circulate the link to too many people.
Otherwise, you can do 2-3 platforms out of it, like YouTube, Zoom, maybe Facebook.
YouTube we are doing currently right now.
Okay. And Facebook also is a good outlook. But look, in some lectures, we saw that problem. I was giving another lecture also, and we had this problem. So they put to Facebook also.
Okay.
And live we were doing at 3 places. So Zoom, Facebook, by Zoom or Google Meet, whatever, Facebook and YouTube. Chalo, let's start. Perfect. So Rajesh, we did the part 1 of the maintenance. Okay. Now we'll do is the second part of it. And second part of it, as we'll see, is that we will do the Domestic Violence Act, the Senior Citizenship Act, and another law, very controversial law at that point of time, which was the Divorced Women's Protection and Provision. So, Muslim Women's Protection of Rights and Divorce, that act. So 3 will do. And if you will recollect, friends, that when we did the first part, we had done at that time Hindu Marriage Act, Hindu Adoption Maintenance Act. At that time, we had done all these special acts and personal acts like, Indian Divorce Act, Parsi, Christian. We had done that because they were all of similar nature. And we had done, apart from that, one secular, which is the 125 CRPC, 125 to 128 CRPC, just to recapitulate what we did previously. And I had at that time left it at a point that, the entire law has evolved from 1956, prior to that also. And finally, we have a parent judgment which we see will last long. That is Rajneesh versus Neha by Justice Indu Malhotra of Supreme Court. So she has almost crystallized the entire act, all the provisions of maintenance into one judgment, and says now what should be done. So I had last time done that part of Rajneesh Neha's also, and we had covered that. So we will come to this. Why we needed this act, protection of women from domestic violence. Now, this was an act was required because in India, till this point of time, till 2005, we never had a act which provided for female reliefs which she would require. We may see some reliefs given under 125, some reliefs given under section 24 and 25, maybe under Hindu adoption and maintenance section 23 talked about provision for alternate accommodation, but separate residence, but it had multiple qualifications. So, there was nothing which was uniform. And we all know that, Vienna Accord of 1994, which provided that, there should be a concerted effort by the government to alleviate, acknowledge domestic violence of women and to take steps to redress that grievances or the suffering. So finally, this act came. Though we can say in the hindsight today that many provisions were crafted which were not well thought of, but by judicial interpretations, we have today defined this act, and it is one of the most beautifully done act, as you can see throughout. It just takes care of everything what a female would require for redressal of her sufferings or for domestic violence. But remember another thing, that this is not a permanent solution. This is only a temporary, immediate relief. That's what domestic violence provides. If you want anything permanent, you will have to approach the civil court or appropriate court. But this provides you even an ex parte order. Like, I'll put a very salutary feature, and that was right of alternate accommodation or being dispossessed from the property. Now, many women face this, that what the husband would do or in-laws would do, they would send the daughter-in-law or their wife to, maybe out for holiday or maybe to her parents' house or wherever, and then lock the door. Now, this became a very, this steps were being taken. Now, there was no easy redressal. With this and this provision of section 19F, or in fact section 19 incomplete will say, that redress that grievances, where the court was given power that, status quo ante can be created. Sometimes when you will read status quo ante, what is mandatory injunction, you will realize that there is status quo ante can be given. That if you are dispossessed, you can be put back into the possession, and that also as an interim measure. Otherwise, when you will do civil law, you will realize that status quo ante or a mandatory injunction is one of the relief which you rarely get at an interim stage. So now, coming to this, we'll just go through the basic provisions, and once we are going through the provision, we will keep on talking about how the act is. So now, first thing first, it defines what is aggrieved person. The aggrieved person is any woman. Now mark the word. It is any woman. It creates a qualification that it can't be any male. It can be a man through a woman, but it has to be woman only. 2, it does not define relationship. It says woman. It does not say wife, children, daughter, mother, grandmother, mother-in-law. It does not define that. So the definition has been kept very wide. Any woman. And that's where the starting point is, that it redresses the grievances or the suffering of a woman. And when we see this definition of woman, and there were many discussions which happened with regard to that, what do you mean by woman? Can a person who is in a live-in relationship, can she ask for any relief? So finally, the Supreme Court defined it in one of its parent judgment. And said that if the relationship is akin to marriage, then the woman is entitled for maintenance, or relief under the Act. And when the Supreme Court was dealing with it, it said that, what are the criteria you would require to say that it's a relationship akin to marriage. So the Supreme Court said first, they should be capable of marrying. So what they do? Requirement of Section 5 of the HMA is put in here. You have to age of majority, you have to be of sane minds, and so on and so forth. You should not have been married previously, and you are not married previously. So, that is one. So you should be competent to contract marriage. Second, it is that you people are living together for significantly long period. That is second. Now, significantly long period has not been defined that it is 1 year, 2 year, 1 month, 5 months, but it is significantly long period. So that is left to the discretion of the court. Third, it said that you remained in a relationship of husband and wife. Means you remained in conjugal relationship. So that is third important criteria. Fourth, it can be that you have children from this relationship. And then Supreme Court added other criteria like, how you were pulling your resources, the financials. Did both of them were combining the resources and the finances and doing it as if they're husband and wife? What was their conduct in society and towards the society and within social atmosphere? So Supreme Court said we all will consider all this to come to a conclusion that, okay, fine, you have been in a relationship which had a nature of permanency. Once it has a nature of permanency, then we'll treat it as a relationship which was akin to marriage. And this we had, but there were many high courts which were doing it. But then finally the Supreme Court decided this in D. Veluswamy, which is 2011 judgment, where it was finally the law was crystallized. Definitely, like another judgment was there of Supreme Court, Indra Sharma. Now, Indra Sharma, Supreme Court said that, look, live-in relationship is good, but it is contra-defined to other relationship, like having a concubine or having a relationship or conjugal relationship for pleasure or for money. So Supreme Court said, no, these all will be culled out. These are not relationship akin to marriage. And then the court proceeded forward to grant that lady entire relief under the DV Act. One of the judgment of Delhi High Court said that, both went to the school for the child's education admission, gave the form, consent form, good enough proof. So, coming to that relation, has to be a woman, and the definition is very, very wide. Now comes second thing is that when you make an application under Section 12 of the Act, so what happens? Any aggrieved person can make an application under Section 12 of the Act. Okay. The first thing the judge will do is call for a domestic incident report. Now, domestic incident report is prepared by an officer who is attached to the police station. So this person, generally it is women who visits the aggrieved person at her house and records everything, what has happened to her, and files this DIR, which we call in short form, to the court. And this is a very important document it becomes for the court to pass any order. But remember, getting DIR is not a reason not to pass an ex parte order. If like I am facing dispossession, I can go to the court will give me the relief, restrain the person from dispossessing me, and then keep on calling the DIR. So this was also a part of anomaly. Sometimes the judges were insisting on DIF, but not clarified with law that you don't have to necessarily wait. Interim orders has to be granted same day when it is required. Now, to fulfill another criteria, it was that who all can file this case. First is woman. That's perfect. But can this woman file case against everyone and anyone? So they said no. And that's why they gave the definition of section 2F. Domestic relationship. Means relationship between two persons who live or have at any point of time lived together in a shared household. Now mark it. It has two qualifications. A, two persons live together at any point of time in a shared household. Both has undergone huge legal debate in many of the judgments. So first thing was living together. What does this word means, living together at any point of time? Now any point of time can be, say, at a time of say marriage is 20 years old, a lady must have stayed with someone in 2000 at the beginning of the marriage, or the lady must have gone for a holiday to some of the relatives' place of her husband. Can this be treated as living together? So the court defined no, it can't be. Living together again has to have a permanency. And it cannot be at any remote point of time. That it can be at any stage of life. No. In fact, one of the cases happened that this lady came back from US and entered into her husband's house. Husband was living in the US. She claimed that it was a shared household, but then household, because there was a severance of relationship. You may have lived at the time of marriage, but when you moved to USA, you created your own house and her. Means you created your own kitchen and you created your own house. There was a severance of relationship. The relationship broke there. So you cannot come back to your parent-in-law's house and claim to be a shared house. And that's where the concept comes in, is of shared household. So you understood that lived together at any point of time cannot be at any point of time. It has to be reasonably proximate. And B, it has to be not everyone. It has to be again qualified. Whom? So where you have lived in domestic relationship or a shared household. And that brings us to the third definition, which is what is shared household. That you will find from 2S. The shared household again was a very loosely drafted, a provision. As I said that when this was made, the provisions, they wanted to give every relief to the women. So they just enlarged the scope, used too many words, and that word became subject of abuse. Like when we read shared household, it said what? Agreed person has lived in domestic relationship in this property at any point of time, whether owned, tenanted, or owned by anyone. Now, imagine this wide definition. Can it be that I and my wife went to my relative's house, stayed there for say 15 days, ate in the common kitchen? Can it become the shared household? One scenario. Second scenario, I go to a hotel. We live together. Can it be a shared household? Third situation, we live in a tenanted accommodation. Husband has moved out. Can the wife claim shared household and will not give possession or hand over possession on eviction to the owner, landlord? So these were extreme circumstances which were never taken care of by the Act. So came many judgments starting from Taruna Batra of Justice Kaju. Justice Kaju said, look, he was very sarcastic or critical about this act, that, a noble act, but framed in a very loosely worded manner. It's not a very legal or legislative words being used. When you will see legislative word, when I always say that IPC has survived from 1860 and it has survived till today. That is how you make an act. Unlike today, when we make an act and we still immediately we go to court to challenge it. And every act comes with a clarification, whether you will see Insolvency Act, we are reading DV Act, you see the Tribunalization Act, every act you will see immediately is challenged in the court and there's an observation by the court on how they have been poorly framed. So here also the same thing happened. And Justice Kaju qualified that again it cannot be any and every household. So he said, hotel, sorry, it can't be. You went to a relative place, good. They extended the hospitality, but it can't be a shared household. See, if you are tenanted property, husband is moved out, if the landlord asks for eviction, you'll have to vacate. Because you cannot jeopardize everyone's right. So shared household was also defined. Now you see 4 qualifications in one word. Woman, lived in domestic relationship, in a shared household, who has suffered domestic violence. If you fulfill these 4 criteria, you are entitled for relief under DV Act. Now, when you see domestic violence also, it has been very widely defined in Section 3 of the Act. It says physical abuse. It also says verbal and emotional abuse. Now, mark the word, emotional abuse, which earlier was not there. It talks about economic abuse, and economic abuse is of many kinds. It's not only deprivation to provide you maintenance. It is also that in many cases in India, what happens? It's a joint business. The moment a dispute happens, the husband surrenders all his right in the property, company assets in favor of his mother, sister, brother, father, whatever, and claims destitution. So now what will wife do? She can say this is an economic abuse. She can go to the DV court and ask for a restraining order that the husband cannot divest himself or dispose of his properties. Similarly, if the economic abuse in a manner that one is that maintenance, second part is that he is giving up his assets and divesting himself. Third can be that she is not being permitted to use the household effects and goods. Now, one thing, a woman suffers in the most hostile condition. I always, when I argue, I say, look, it's like being caught in an enemy or terror camp. Because a daughter-in-law is made to suffer in the house, which is her matrimonial home, where everyone is against her and she's alone. So that's why I always try to develop this analogy that, a woman's suffering will be at a place which is so hostile that can be compared as being caught in an enemy's camp. Then no one will support you, no evidence will be in your favor, and still you may have to come to court and defend yourself. And when such happens, things is there, then definitely the law has to be defined in some manner, which has to be wide encompassing. So coming back, friends, here to Section 12 of the Act, which says you can file an application. On looking at the definitions, yes, Section 12 provides that you can file an application. Though the Act provides timelines which, we never follow now. Like it says that the date of hearing should not be more than 3 days. It should be decided in 60 days. Well, we don't achieve any of them. But at least the interim protections are being granted. Like restraining order from being removed from the shared household is one thing courts are easily granting, at least in Delhi and in metropolis. And I'm sure in Jharkhand also, Rajesh can confirm, and you people are budding lawyer, you can also see there that the courts are granting. And High Court is definitely very, very liberal about it. Okay. So what does the court does? Court issues notice and may grant interim protection. Now for service, it is not that the lady has to run around to serve the respondent. The court directs the protection officer, who is the police officer of the concerned area, to serve the respondents. Again, very important step. Because service in India, pre-COVID time, was very difficult. You know, a woman does not have resource. How can she go to her husband's place to serve her? They may not accept the service also. They may not accept the summons. They may again abuse her. And assume that she is living in this house, hostile house. So what will happen? That's why they said a protection officer will go. So that the message goes clearly to the respondents that I am there as her protection officer and no one can do any harm to her. And this is your summon, come to court. So woman is saved from harassment of affecting service, and further she is strengthened that you have a protection officer appointed by the court to look after you. Now here also, you know, very interesting development of law took place when we talk about respondent. You know, the way it was qualified, it said adult male respondent. When you will read section 2Q, it used to provide that. So there was a whole dispute and debate whether it is adult male only who can be made respondent. Finally, the judicial interpretation came that it can't be only adult male, it has to be, it can be female also. Because otherwise it would be only men against women or women against men. So that was not the idea of the act. So once an application is filed, notice is issued, protection officer is appointed. Protection officer is also the act provides that the protection officer can also be directed to go and ensure the safety of the lady. So once that is done, then we come to the relief part. What are the reliefs? You know, section 18, 19, 20, 23 are the provisions. 18 talks about, in fact 17 also I will try to say, the section 17 says right to reside in the shared household. Now look at the word that it starts. It starts with non-obstante clause. Notwithstanding anything contained in any other law for the time being in force, every woman shall have a right to reside in shared household. Look at how beautifully they've done it here. Notwithstanding anything contained in any law. That we call in legal term non-obstante clause, means it stands out against every law. Like when section 4, Hindu Succession Act was created, it had section 4. Non-obstante clause it had. Because then they said, okay, fine, all the customary law has to go. This will be the only law. And we will go further in my debate and discussion. And when we'll come to Senior Citizenship Act, there also there is a problem. There also there is a non-obstante clause. So DV Act and Senior Citizenship Act is in conflict today. When we'll come there, then I'll address this part, that how they're in conflict. So you have a right of shared household. You have a right of protection orders under section 18. And various protection orders are there. It's not one. But I am at this point, because we are doing the provisions of maintenance only, I am ignoring all this, except I will show you section 18E, which says that you cannot alienate any assets, bank lockers, bank accounts, which has been enjoyed by both the parties. Whether operate singly or jointly, it's irrelevant. And right of residence, if you see section 19, definitely 19F says that the court has a power to grant alternate accommodation of same stature. Like in some situation, what happens is that the husband comes that, look, this lady has made a false allegation against me. Or maybe she has made a false allegation of 376 against my father. We cannot stay in the same house. Delhi is a flat house. They are flats. So she may again tomorrow lodge another complaint FIR against us. So in this compelling circumstances, the court has a power to give you alternate accommodation. That, okay, fine, you are enjoying a house which has a rent of say 10,000. You please go search for a house of 10,000 and we'll pay you 10. The husband will pay you 10,000. So right of alternate accommodation. Or otherwise it is that you should not be dispossessed from that house, which is 19A. But that is one part of it. Now you see what is the beauty here. What has been further added? It further adds that not only you will not be dispossessed, maybe your husband will be removed from the house or your parents-in-law will be removed from the house. So if the situation is so bad that the woman feels that if this lady, my in-laws or my husband is dead in the house, my life or security is under threat, the court can direct for their removal of the house. Or if suppose it is ground floor and first floor property, the court can direct that the respondents would not come to the floor or the portion where the wife is residing. So the law, they have made it in a manner that you can get, as I say, any relief which is expedient to provide or alleviate the suffering of that woman. And to enforce this, the court also can direct the police officer of the concerned area to look into and provide for that. So this is residence, separately dealt with. Then comes 20, monetary relief. Now we all have argued that, okay, fine, monetary relief is what? Maintenance. But here they go beyond. Though normally courts are not giving so much of relief as this section talks, but look at the provision this section provides. A, loss of earning. Assume the woman has not been able to work because of her marriage or children or because of domestic violence. She has lost her earning. She was educated enough. Maybe before marriage she was working, but after marriage she has not worked because of these compelling circumstances. Then the monetary relief has to be granted for that. Medical expenses, removal of any properties, and maintenance definitely. And we have, first session we have all done that maintenance of what can be the maintenance. It has to be reasonable maintenance. It has to be a fair maintenance. It has to be maintenance in accordance with the lifestyle which the lady has lived. And as Justice Indu Malhotra said, it should not be an act of undue enrichment. At the same time, it should not be such that the woman is suffering or living in penury. Okay, so this is what section 20 provides for. In fact, section 22 also is interesting in a manner that it provides for compensation order. It says that the court has the power to grant compensation for damages or injuries. Now, just now we argued, in fact, in this COVID time, we argued a case where the husband lived in Kuwait after marriage since 1985. And when he came to India, so he stayed he went to Nainital and he was staying there with another lady. So at interim stage, court granted us compensation. That this is an injury which she has suffered. Maintenance is separate. Injury which she has suffered, so one-time compensation. The section 23 provides granting all this relief ex parte orders. So the magistrate has the power to grant ex parte, means at the stage of notice before serving notice on the respondents. Apart from this, now it's not that, when these provisions are there, it's not that, a woman can come, have mischief and run away. Because we understand the cases of mischief is there, misuse of law is there. And so you have section 25, where you can go to the court stating change of circumstances and asking for modification or reversal of any order which has been passed under section 17, 18, 19, 20 or 22. Any of this. So section 25 provides for modification. Now section 26 is one of the very unique provision in law. You will normally not find anywhere. But I have not seen a parallel of this yet. It says that DV Act can be invoked in any proceedings. So what it primarily says is that section 18, 19, 21 and 22, which are temporary relief sections, they can be invoked in any provision of law. So assume, like I did in one case, we were doing this case against a member of parliamentarian who was 7 times member of parliamentarian. I'll not name the family members, but in the suit for partition, we invoked DV, and for this lady against her husband, we asked for maintenance, and we got maintenance sustained in division before division bench of the Delhi High Court and by Honorable Supreme Court. So this is a very unique provision that you can invoke this anywhere and everywhere. Then comes the jurisdiction clause. Now jurisdiction is such that it can be filed where the lady resides, woman resides temporarily or permanently. Where the husband resides, that's fine. Where the cause of action happens, that's fine. Two clauses are very unique. A, where the woman resides temporarily. And second, where the husband carries on his business, is employed. So it extends the jurisdiction. Anywhere this lady can file the case. Definitely the procedure has been under Criminal Procedure Court. And the reason is very straight, because a lot of powers has been given to the court for the purposes of enforcement. Okay. Now we have only one provision left there, and that is section 31, which says that if there is a breach, then what happens? If there is a breach of protection order, then the court can register an FIR and take various measures. So this is the entire provision of law. Rajesh, one issue, do we do the question answers, do we do question answer, act-wise, or do we do it at the end?
As you may wish.
I only feel that, putting in between is good, because then we have done the section and the question answer, but it will not derail the time. That's my fear.
Yeah, yes. So if they ask relevant questions, they may just ask them, and you may just answer them. If the question is irrelevant or not related to that particular act, we may.
In fact, my colleague Sagun has a very good suggestion. We'll fix it to 10 questions maximum.
Okay, good enough. Yeah. So you can announce this, no? So
yes.
Yeah.
So everyone, please formulate a question, and since we have a restriction of 10 questions, make a relevant question, and someone has asked the same question, please don't ask that question. Who's the first person to shoot?
कोई जो अभी तक जो लेक्चर हो गया, जो टॉक हो गया, उससे संबंधित कोई भी प्रश्न पूछना चाहे तो पूछें. कोई डाउट है किसी को तो? Good enough. तो लगता है कि you've been clear enough. So we can proceed. Yeah. और इसी तरीके से अगर कहीं पे किसी को कोई प्रश्न समझ में आता हो तो वो पूछ सकते हैं, बस ये ध्यान रखें कि वो रेलेवेंट क्वेश्चन हो, है ना?
ठीक है, perfect, Rajesh. So we'll go to the second part of our lecture, which is Muslim Women Protection of Rights on Divorce Act 1986. Now, this is a very interesting provision of law where you will see the tussle between Supreme Court and the government and the parliament, and how, appeasement policy for one segment prevails upon the court, on the judicial, on the legislature, the parliament. So what happened is that, when we read Muslim law, we say that they were bound by their own customary law, because they are bound by their own customary law because their law has not yet been codified, like Hindu Marriage Act or Hindu Succession Act, or say Indian Divorce Act and things like that. So there was a lot of conflict. What will be the maintenance to be provided? How it is to be provided? What is to be provided? Now, previously, it was that a divorced woman had effectively no right. What she was entitled for, meher, and maintenance for the period of iddat. Now, iddat is 3 reproductive cycles, as we understand, a menstrual cycle. So, you are only provided for 3 months. And if the woman has crossed the reproductive cycle age, then for 3 lunar months. So the difficulty was that the woman, after 3 months, what she'll do if she is not capable of providing for herself, if she is not remarried, if she does not have independent source, then what she can do? So came the judgment of Sabano. Sabano's judgment, which was passed by Justice Chandrachud, very landmark judgment. And it says that right of a woman under Section 125 cannot be impaired by any customary law. She will be entitled for maintenance and protection under Section 125 of the CRPC. And he, in fact, he read one of the provision of the act itself, what do you call, one of the verses of the Quran itself, 241, ayat 241. And it says that in ayat 241, it provides for, the word used is provision. And it says, for a divorced woman, let there be fair provision. This is an obligation of those who are mindful of God. Now, Supreme Court held on this interpretation. A lot of people argued. They brought judgments after judgments, theological and religious book, saying that provision is not maintenance. And Supreme Court in its judgment says it's strange. Provision and maintenance are not antithetical or opposed to each other. They are same. They say the same thing. And so the Supreme Court passed this judgment. Now, this led to a lot of debates and fights. Finally, the Parliament sits down, and we see many cases. In fact, now we see in tribunalization case also, this time Parliament is doing the same. You have the judgment of Madras High Court upheld by Supreme Court, and the legislature has upturned it by their own act. So, this fight between judiciary and legislature always happens. Definitely the most celebrated fight was Kesav Nand Bharti, and before that Golaknath. That is a separate cases and situations. But so the Parliament passed this act, which was Muslim Women Protection of Rights on Divorce Acts. Now, why divorce acts? Understand. Because when you read Hindu Marriage Act or you read any of this DV Act, it does not talk about divorce women. But in Muslim law, why they talk about divorce women? Because here the divorce can be granted with lot of ease and comfort. In fact, we have heard cases where the divorce has been granted over phone. I have done a case, Afsha's case, where the divorce was granted like this only. She was in Delhi, the husband was in Bangalore. He calls the Maulvi there and, he pronounces. At that time, that form of talaq was a valid talaq. So when you give the divorce so easily, and then you provide only for 3 years, 3 months, where this lady will go? Or if she has an unborn child or a born child, maybe you have to provide only till the birth of the child. And what will happen thereafter? So this was a very difficult question, which needed an answer. So when this act came, statement of object of this act is very intriguing. It says Supreme Court in Muhammad Ahmad Khan versus Shah Banu Begum has held that the Muslim law limits husband's liability to provide for maintenance to divorced wife for a period of iddah. It does not contemplate the situation envisaged under Section 125 of the CRPC. The court therefore came to the conclusion that a divorced wife, if not able to maintain herself, then she is entitled to be maintained in terms of Section 125 of the CRPC. Now, to offset this finding of Supreme Court, this act came. Now, this act definitely, when it came, it also went through various challenges. There were many high courts where they said this act is bad. Many high courts said this act is good. And debate as usual happened. And, you have the most celebrated judgment of just Daniel Latifi. Now, in this case, he was a lawyer in Madhya Pradesh. He divorced his wife. His wife asked for maintenance. The marriage was more than 40 years and his wife asked for maintenance. The court under 125 granted her maintenance. When the husband realized that he has to give maintenance, he divorced her for pronouncing the triple word. Gave her the meher and said, I'll not provide you any further maintenance. This lady had 5 children, 40 years in the marriage. How she could have survived? And meher, which was fixed 50 years back. If 50 years back, say meher of 5,000 was fixed, in 40 years time down that line, that 5 years meant nothing. If you take the inflation, interest, everything. Yes, maybe you had converted into a gold value and said, okay, fine, 5,000 worth of gold I'll give you now. That's a different thing, but that's not the case. You give 5,000, which was fixed 50 years back or 20 years back or whatever. So this judgment this act came to Supreme Court for interpretation. Now here, Justice Patnaik, we had a very nice bench here also. In fact, first time also we had Justice Chandrachud, Justice Ranganath Mishra, Justice Desai, Justice Reddy. We had here also we had similarly very robust bench. We had Justice Patnaik and Rajendra Babu, Mohapatra, Durai Sami, Shivraj Patil, very, very interesting judges and who would think out of box. So what they did now, they did a very clever job, Rajesh. They said, Shah Banu offset by this act. If we say this act is bad, because the virus of the act has been challenged. So if we say this act is bad, then again Parliament will do something. So they decided a very clever usage of word, and that you will find it here now. They said this act is valid. And we interpret this act. And within the meaning of this interpretation, the husband has to provide her maintenance for her entire period after granting her divorce till she either remarries or till she, becomes capable of maintaining herself. So this act came because legislature thought they were and they made this provision 3. The very short act, in fact, provision 3 and provision 4. So what this provision 3 reads, meher or other properties. A reasonable and a fair provision and maintenance to be made and paid to her within the period of iddat by her former husband. Now, mark the word fair and reasonable provision and maintenance to be made and paid to her within the period of iddat by her former husband. Second, it said that where she has a child or children born, then again the same language, fair and reasonable provision and maintenance to be made and paid by her husband, but for a period of 2 years. Now what Supreme Court said? It says, yes, the act is very clear. You have to make the provision for maintenance, which is fair and reasonable. You have to not only make, but you have to pay, and you have to pay within the period of iddat. But this act nowhere says that you have to only provide for 3 months. It only says you have to provide before the period of iddat. And this is how they interpreted the entire act. That you will pay before the period of iddat, but you will pay for the entire period. And that's what the beauty of judicial interpretation is in this case. And as I was pointing out, that finally the Supreme Court reiterated the view of Gujarat, Kerala and Bombay High Court and said that is the view it should be taken, and definitely Patna High Court and the other high courts were overruled. So just to quote unquote, I'll read that one line for you people. And it says, he is liable to make the provision for the future of his divorced wife. Such provision includes maintenance for the wife as well as. And then it says, it extends for the period beyond iddat, but must be made within iddat. Now, this made a very, the entire interpretation became so difficult for these, husbands who thought they were very clever, like this lawyer, he thought very clever, how to defeat 125, give a divorce. Now, his life became extremely difficult, that you have to provide for her entire life in that 3 months. So that's how the Supreme Court got hold of the neck of this erring husband who wanted to leave their wife for whatever good, bad reasons. And then Supreme Court said, okay, fine. This 2 year period for the child and how they interpreted it. That also interpretation is very interesting. They said this is for the divorced wife, that she can ask only for 2 years, but it does not say that the child cannot go to the court and ask for money. So child's right under 125 is protected. The child or children can go, a minor can go to the court and ask for maintenance, and that right remains protected by virtue of this act itself. Secondly, the husband has to provide for the entire future period of the wife and has to provide within that 3 months. And the Supreme Court also relied upon that ayat 241 and the mata, what they say, MATA, mata, they said. That mata, they says it's basically a provision for, it says provision and does not say maintenance. So beautifully they harmoniously balanced this act with the requirement of that aggrieved woman, which otherwise the intent of the legislature was to deprive her. And fortunately, that interpretation remains till today. So, this interesting tussle between legislature and judiciary, again judiciary won and showed its wits and wisdom, like they won in case of Nanda Bharti. Before that, we have seen R.C. Cooper's case. So we have seen many times, and every time judiciary which wins because of their wisdom and knowledge. And parliament, definitely Indian parliaments and parliamentarians, we know how good they are. So when it says that, it also says, then understand that for compliances and everything, this act is almost similar to 125 and 128. It says the same thing, that if you don't comply, warrant can be issued, you can be sent to jail, and so on and so forth. But what is relevant here is that the husband has to provide for. Definitely alternates are provided in section 4 also in this, though not very widely enforced now. But it says that where the husband is not there, then what happens? Then the relative will provide for her maintenance if that relative is inheriting the property. Now this you will find some correlation with section 20, 21, 22 of the Hindu Adoption and Maintenance Act also. There also it is like this. The relative who inherits will have to provide. Similarly, you will find in the Senior Citizenship Act also, similar situation. Here there is one thing more, that if the relative is also not able to provide, then yes, the state Waqf board has an obligation to provide maintenance. So that is one step more. So this is a very short act, passed in a complete haste, but very well balanced by Supreme Court and protected the right of this destitute woman who was being made victim of a clever husband. So today, in fact, now after passing of the DV, there are many things which remains now protected and clear. So even though we say that...
सर माफी चाहते हैं सर, आपसे निवेदन है कि थोड़ा हिंदी में सर बोलेंगे थोड़ा सा।
बिल्कुल सर, बिल्कुल
सर मिक्स करके बोल देंगे तो
मिक्स करके बोलो, एक कोशिश करता मैं भी।
यस सर, मिक्स करके ही बताया तो दैट वुड बी मोर बेटर फॉर अस।
I can understand. See संजीव, कुछ यहाँ पे थोड़ा से हिंदी मीडियम वाले भी स्टूडेंट्स हैं और कुछ हिंदी मीडियम वाले लॉयर्स भी हैं। तो एक्चुअली आई टेल यू पीपल, ये एक्चुअली दिल्ली में थोड़ा सा जो माहौल है और जिस लेवल पे संजीव जी अभी ऑपरेट करते हैं, तो ज्यादा फ्लो में तब बोल पाते हैं जब इंग्लिश में बोले। तो अगर हिंदी में उनको बोलना होगा तो थोड़ा सा उनको थोड़ा सा रुक के कभी थोड़ा सा समझ करके बोलना होगा, है ना। तो हो सकता है कि वो आपको उतना अच्छा न लगे, जबकि ये चूंकि आप लोग हैं तो इसलिए ये खुद ही जानबूझ करके काफी धीरे धीरे बोल रहे हैं ताकि आपको समझ में आए। परंतु अगर आप चाहते हैं तो ये फिर भी ट्राई कर लेंगे कुछ।
यस सर, नो इशू सर, मिक्स करके बता दे तो ज्यादा बेटर होगा सर हमारे लिए।
हाँ ठीक
सर जितना हिंदी से बोल सकते हैं और जितना हिंदी में वो बोल सकते हैं हम लोग कोई आपत्ति, लेकिन कोशिश करें हिंदी में बोलने का, ताकि कुछ भी
कोशिश तो खैर वो तो कर ही लेंगे, है ना। वो तो लेकिन ज्यादा अच्छा फ्लो आता है लॉ में। एनीवे ठीक है संजीव, लेट अस लीव इट टू संजीव जी, because he's working so hard for you people. Let us be obliged and let us give him that freedom. हम लोग तो YouTube में भी इसको बार-बार ये करके और समझ लेंगे। तो हमको लगता है ये चीज आपके लिए बेहतर रहेगा कि आप इनको बोलने दें अभी और बाद में उसको धीरे-धीरे करके सुन के समझ लें, वो ज्यादा अच्छा रहता है।
Okay sir, let us continue.
Let us continue. Whatever is comfortable for Sanjeev ji, that let us continue in that manner. है ना
राजेश, जैसे मैं काम करता हूँ, ये आफ्टर कंप्लीटिंग इन इंग्लिश आई पुट 2 मिनट्स इन हिंदी सो दैट मुझे समझ में आए। ऐसा बात नहीं है कि हम लोग हिंदी नहीं बोल सकते। हाँ, बट तुमने एक बात तो सही बोला कि जो फ्लो इंग्लिश में आती है वो हिंदी में मेरी नहीं आएगी, नहीं आ पाता है। किसी भी कोई भी जो लॉयर जो उस लेवल पे ऑपरेट कर रहा है, तो जजमेंट का चीज, लॉ की इंटरप्रिटेशन का चीज वो इंग्लिश में ही आता है। आप लोग ये चीज रियलाइज करेंगे लेटर ऑन। और ये हमारा कहना है कि जिनको भी कुछ भी थोड़ा डाउट होता है ना, वो हिंदी में क्वेश्चंस पुट करें, उसका हिंदी में जवाब दिया जाएगा। एकदम वो बात है, कोई प्रॉब्लम नहीं है, वो डिफिकल्ट। ठीक, आप सवाल हिंदी में एकदम पूछ सकते हैं और मैं कोशिश भी करूंगा कि हिंदी में जितना हो सके उतना जवाब हिंदी में दे।
जी सर जी।
अब जैसे मैंने आपको ये बताया डिवोर्स वुमेन का जो लॉ बताया, उसमें अगर उसको मैं हिंदी में बोलूंगा और 2 लाइन में 3 लाइन में मुझे बताना पड़ेगा, तो ये है कि सुप्रीम कोर्ट ने ये बोला कि जो मुस्लिम वुमन जिसको डिवोर्स दिया गया है उसको मेंटेनेंस मिलनी चाहिए, और उनको मेंटेनेंस उस समय तक मिलेगी जब तक वो रिमैरिड ना हो या केपेबल ऑफ अर्निंग ना हो, और ये ड्यूटी उनके हस्बैंड का है। ये सुप्रीम कोर्ट ने लॉ इंटरप्रेट किया दानियल लतीफी में, ठीक है। दूसरी चीज सुप्रीम कोर्ट ने बोला कि ये 2 साल जो बच्चे का मेंटेनेंस केवल प्रोवाइड करने वाला जो सेक्शन 3 में दिया है, ये तो दिया है कि भाई वो औरत मांग सकती है 2 साल के लिए, लेकिन अगर बच्चा खुद कोर्ट गया तो उसको पूरा मिलेगा सेक्शन 125 में। तो इस तरीके से उन्होंने लॉ को इंटरप्रेट किया और इन फेवर ऑफ वुमेन बनाया, ठीक है। So I'll come to the third part of it, Rajesh, now. That is the Maintenance and Welfare of Parents and Senior Citizens Act. Now, this is also one of the act which is very, very relevant and important. We heard that...
Sir, I have 2 questions regarding that one.
Yes.
Sir, first question is that कि जो मेहर से इद्दत है वो सर 3 महीने का ड्यूरेशन और 2 साल का ड्यूरेशन दोनों को बोलते हैं, वो इद्दत वर्ड उसके लिए यूज होता है?
नहीं, इद्दत जो है वो अगर आप मुस्लिम कस्टमरी लॉ भी देखेंगे ना, तो वो पीरियड ऑफ इद्दत इज मींस पीरियड ऑफ प्यूरिफिकेशन, एंड प्यूरिफिकेशन प्राइमरली इज ओनली 3 months. The idea is that the woman who has been divorced, वो 3 महीने के पीरियड रखा इसलिए गया कि if she has conceived say from the previous husband, then it will be known to the world that she has conceived from the previous husband. That's why period of iddat. Iddat means purification. ये 2 years जो है वो completely different है, वो for child's maintenance है, वो period of iddat से नहीं दिया।
Yes sir, I got that. And the second one, I think it is relevant for this topic or not. Actually, I want to ask कि सर जैसे ये एक्ट बन गया, पास हो गया, और 3 तलाक एंड साबानो केस एवरीथिंग, उसके बाद जब आता है कि अभी भी हम लोग बहुत इंटीरियर एरियाज में जाते हैं, तो उस एरियाज में अभी भी लोग अपने कास्टिसीम्स के अकॉर्डिंग फॉलो कर रहे हैं, हमारे लॉ के अकॉर्डिंग फॉलो नहीं कर रहे इस चीज को। सर तो उस प्लेस पे क्या एक्शन होना चाहिए एज अ लॉयर, एज एन एडवोकेट, एंड सर हमारे जो पुलिस है या फिर जो भी हमारे प्रोटेक्टिव लॉज हैं उसके अकॉर्डिंग वहाँ पे क्या रोल होना चाहिए हमारा?
देखिए, बहुत तरीके से ये तो आप कह रहे हैं कि भाई लॉ का इन्फोर्समेंट नहीं हो पा रहा है इंटीरियर्स में, मे बी वहां पर औरतों को पता ना हो पूरी बातें, मे बी ये है कि वो फियर में रहती हैं सोसाइटल के, तो इसलिए नहीं कर पाती हैं। इसमें तो अगर वहां पर वॉलेंट्री ऑर्गेनाइजेशंस हो जो लीगल फील्ड में अवेयरनेस क्रिएट करता हो, जो हम लोग कहते हैं विधि शास्त्र में, या जो वुमेन कॉज के लिए लड़ता हो, तो ऐसे बहुत सारे ऑर्गेनाइजेशन हैं, एनजीओज हैं, जिससे आप एसोसिएट करके वहां पर भी एक चैप्टर खोलें, उसका भी एक अध्याय खोले वहां पर, और कोशिश करें कि वहां पर आस्ते आस्ते करके एक एक करके महिलाओं को जोड़े, ताकि उनको आइडिया मिले, नॉलेज हो, और नॉलेज इज एम्पावरमेंट। जब आपको नॉलेज मिलता है तो वही आपकी पावर है।
Yes sir, that's the most reason.
ये जैसे आप बोल रहे ट्राइबल्स, आप ये देखो कि अभी तो हमने स्टैन स्वामी का सुना इतना कि भाई उनको यूएपीए में लेके गया, लेकिन अगर आप स्टैन स्वामी का कभी आप देखेंगे, पढ़ेंगे उसके बारे में, तो उन्होंने भी जो वहां पर सिस्टम शुरू किया था, पत्तलगढ़ी और ऑल, अगर आप कभी पढ़ेंगे उसको तो आप देखेंगे उन्होंने कैसे एक एक करके आदमी को जोड़ा उसमें और उनको एम्पावर किया, उनके राइट्स को बताया। नहीं तो उस एरिया में तो बहुत मुश्किल थी। होता क्या था कि ये ट्राइबल्स में अल्कोहलिज्म का प्रॉब्लम होता था, कोई बाहर से आदमी आता था, अल्कोहल पिलाता था, उनका गोठा ले लिया, बोलता प्रॉपर्टी मेरी है। डेफिनेटली बाद में लॉ भी बन गई, यू कांट डू इट, बट शुरू में एक्सप्लॉयटेशन थी। सो एम्पावरमेंट तो इंडिविजुअल लेवल पे ही करना पड़ता है। अब जैसे कैलाश शास्त्री आती हैं, वो चाइल्ड लेबर स्लेवरी उनके अगेंस्ट कर रहे हैं। ये तो एनफोर्समेंट जो पार्ट है ना, वो अगर आपको अच्छा लगता है तो आप कोई भी ऑर्गेनाइजेशन से मिले, उनसे बात करें और वहां पर उसका एक चैप्टर शुरू करें। ठीक है?
Okay, thank you.
So coming to the last part of it, that is maintenance and welfare of parents and senior citizens. Now this is also very important because, you know, many times what happens, parents in old age, they are left on the streets or on destitution or in old age home. But today we know the classic case of Singhania. We knew the J.K. Singhania and the face of J.K. Singhania when he flew the aircraft. And today see what his son has done to him. He lives in destitution because entire property which is worth 10,000 crore has been taken over by the son. So what happens in this kind of situation? Does this parents, assume by parents by love, gives the entire property during his lifetime to his children or child, and then the child decides, oh, now I've got the property, why I want to suffer the burden of old age, throw him out. So there are many this was of my own property. Very strong, stark cases. There's another case. Rajesh and we have been taught by Lalita Sarkar. She's unfortunately died recently only. Professor of law. Her property in Hauch Khas was taken over by a DGP of police from Bihar only. Through a gift deed, registered gift deed. And then she was being pushed to starvation. So these were very, very strong cases where the old age, when you have no resource and no strength to fight and you are suffering. So when this act came, it says that, you know, the children have an obligation to provide. And that's what was Section 4 of the Act. It says where the parents are unable to provide for themselves, then it is the children to provide for them. If the children is not there, then the relatives who will inherit his or her property. And it can be one relative or many relative. It can be also important to the way they inherit. So, important fact that happened was that a senior citizen have a protection. It also says that it is not that the senior citizen himself has to come to court. He may come if he has the strength, but if he is incapable, any other person can come to the court on his behalf. In fact, an organization authorized by him also can come to the court. Or in worst situation, the tribunal can sue him to take cognizance of that. Say a senior citizen is bedridden, then what happens in that situation? The tribunal can sue him to take action. So this is how they said that Senior Citizenship Act came in. And it is not a normal civil court, understand. We go to SDM for enforcement of this order. And SDM has been given all comprehensive power of restoration of possession, of grant of possession, of grant of maintenance, enforcement of these rights, and including declaration of the documents to be null and void. Like what happened in Lalita's case, she had done a registered gift deed and she was living in destitution. So this case was filed before the SDM, and against that the matter came to High Court. And the other side's defense was, that police officer's defense was, that it's a registered document. And registered document has a validity of enforcement of Section 78 of the Evidence Act. And because it's a valid document, you cannot set aside in a summary manner like this, that, okay, fine, SDM decides and says this is bad in law. Their whole defense was that it has to be a complete trial. And High Court gave very strongly. Fortunately, we had Justice Muralidhar, who was also taught by the same Lalita Sarkar. And he says so, that I was taught by her. I am aggrieved. And what he did? The entire gift deed registered was cancelled, declared null and void. Property was restored to her. Similarly, the judge of the Punjab and Haryana High Court, property was restored to him. So these powers were given. And here when you see, again, there's another act, if you see and compare with domestic violence. Here you see the powers were more summary in nature. And here you don't even have to go to civil court. Here you don't even have to go personally. So this is how they enlarge the scope from the Domestic Violence Act, DV Act. And here if you see what the court has to do, SDM has to do, he has to conduct inquiry. It is not trial. It is not a proceeding. He will only conduct an inquiry. And that inquiry is sufficient for him to make an order. And this order is enforceable by law. And breach of it can call for sentences and imprisonment. This is the whole act of section 4 and 5. Very small act it will be. We'll just cover it. But this is the primary two sections of it. Section 6 talks about jurisdiction. And definitely jurisdiction is, as we say, very, very wide. It can be anywhere as per the convenience of this senior citizen. It can be filed. Then it talks about 7, constitution of tribunals. It says it's presided by officer not below the rank of SDO, which is subdivisional officer. And it has to be everywhere. Section 9 provides for maintenance. Now, I'm not going into any further details like maintenance because I've already dealt with it many, many times. Section 16 provides for appeal. So the aggrieved person can file an appeal within 60 days. In fact, Section 20 I liked of this act, which says that, you can provide for hospitals, has to be provided by the state government. So when you see this, an important section which will come in is Section 23, which I told you, that transfer of property to be void in certain cases. As I told you, the case of Lalita Sarkar, that it can be declared void and in a summary manner. So the court said that the legislature says that if the children has benefited from his own parents, he has a moral and legal obligation to provide for them. You cannot abandon them. And made non-enforcement an offense. And most importantly, it says Section 27. No civil court shall have jurisdiction in it. In fact, the court went, the legislature was overexcited and they said even lawyers have no right to participate till various judgment games said that no, lawyers will participate. So that is a saving grace for lawyers. But if you put it like this, if I have to put this entire act into 4 lines, I'll say A, that it's an obligation to provide maintenance. An obligation can be of children, relatives who inherit. B, even a document executed by the senior citizen can be declared null and void. All this can be done by virtue of inquiry and in a summary manner. So strong acts were there. But now what happened was that it had a Rule 23, which says action plan. That every state government will make their own action plan for enforcement. So like Punjab and Haryana has an action plan, Delhi has an action plan. Now this action plan became a subject of huge interpretations and judicial discussion. Because in many, many cases it was happening that where there was a dispute of husband and wife, and knowing India, the property mostly are in the name of the parents would say, go to the tribunal and say, I want to throw my daughter out of this property. And the tribunals were passing that order. So it became a problem that this lady, a destitute, again, a daughter-in-law is also a destitute. We call her an aggrieved woman under Section 2 of the DV Act. So then the judgment came, no, you cannot ask only the daughter-in-law to leave. You have to ask both husband and daughter-in-law to leave. Then it is maintainable. Then it's fair. Because both will go out. And so many judgments started coming in, where the court would direct both husband and wife to go out. But when this was almost being uniformly followed in Delhi, Maharashtra, Punjab was many cases, Haryana many cases, till we come to 2020. In fact, 2019, I was arguing this provision of law ex extenso in Punjab and Haryana High Court. And I was for the parents-in-law in that case. So I had to defend the act and the eviction order also. So came the judgment of Justice Raina of Punjab and Haryana High Court at that time, that this action plan, which is an administrative act, cannot take form of a substantive law. And so he held it ultra vire and bad in law. Now that is the first break we see in this somewhat misuse of the provision by senior citizens to help their own children in their matrimonial dispute. So after that, few cases came in Delhi High Court. And Delhi High Court, like Justice Asa Menon and I think Justice Rekha Palli, they all said that there should be a fair balance. It cannot be that because now you see the word non-obstante clause here coming in, that because 2006 clause, that doesn't mean it will overrule completely the Domestic Violence Act. So they said there should be a harmonious relation. Now what one or two judgments, what they said, harmonious relation, that okay, fine, we'll grant eviction, but provide her alternate accommodation. So that is harmonious interpretation. Finally, this provision has also gone to Supreme Court, and Chandrachud has dealt with it, the entire case law. And he has upheld Delhi's view that there should be harmonious interpretation of both the Act, that is DV Act and Maintenance Act. And in S. Vanita's judgment, the court has said that you cannot say that the right of a woman is inferior to the right of the parents-in-law, but at the same time, right of the parent-in-law is also not inferior to the right of the woman. So what court has to see is see the entire factual situation and come to the right conclusion. So here, a lot of discretion now has been given to the court to decide and adjudicate upon. Earlier, it was from 2007 to effectively 2020. It was that a senior citizen would go to a tribunal and there will be an eviction. But now there's a break there. It has to be in the manner that the woman also does not suffer, but at the same time, the parents-in-law also does not suffer. But none of the provision of law has been declared as bad. Like Section 23, cancellation of entire document. It's not that it's declared bad. All the provisions remains enforced and intact. So we conclude here. If you people have questions, please ask.
Sir, if sir, good evening. Suppose there is a parent, and they have only one girl child or two girl child. They got married and they already separated, but their parents become old. In that case, what can be the situation? They go and sue them that they are not taking care of me because they are daughters.
No, why it says daughter? It says children. It can be anyone. It's gender free.
Okay. But after married, they'll go to their own in-laws' house. So is it still they are liable to take care of their parents?
Yes. Why we live in 22nd, 21st century now. Women, children, daughters have equal responsibility to provide for their parents.
So happy to hear this. Thank you so much, sir.
I won a case on this ground itself.
सर मेरा एक क्वेश्चन है कि पति घर में काम करता है, चूल्हा चौका करता है, वाइफ टीचर है, गवर्नमेंट जॉब करती है। अब वो पत्नी चाहती है कि हम उनसे हस्बैंड से तलाक लेके चले जाए, कोई दूसरे सैलरीड पर्सन से शादी करे, तो क्या इस कंडीशन में हस्बैंड मेंटेनेंस के लिए पत्नी के अगेंस्ट कोर्ट में केस दायर कर सकता है?
एकदम सेक्शन 24 में भी प्रोविजन है, ये डाल सकते हैं। लेकिन हाँ, वहां पर हस्बैंड को ये दिखलाना पड़ेगा। मैंने अगर आप पिछला वाला मेरा लेक्चर सुनेंगे तो इसमें पूरी आंसर उसके आपको वहां मिलेगी। मैंने वो लेक्चर में बोला था कि अंडर व्हाट सर्कमस्टेंसेस हस्बैंड विल गेट मेंटेनेंस। ठीक है
जी
सर, गुड इवनिंग। क्वेश्चन मेरा भी है।
हाँ बोले।
मेरा क्वेश्चन ये है कि ये कोई ऐसा डिसीजन है जिसमें कि ये क्लेरिफाई हो कि बच्चों में कैसे लायबिलिटी को डिस्ट्रीब्यूट किया जाए। सपोज करें कि ओल्ड पेरेंट्स के 4 बच्चे हैं, तो लायबिलिटी कैसे डिस्ट्रीब्यूट होगा?
इसमें अगेन अगर आप एक्ट इटसेल्फ देख लें ना तो उसमें बड़ा क्लियर है कि कैसे प्रोविजन होगी। और माइक्रो लेवल पे कि एक बच्चा 100 रुपया देगा या दूसरा बच्चा 50 रुपया देगा, ये डिस्क्रिशन कोर्ट को दिया गया है कि वो कोर्ट फिर असेस करेगा कि पेरेंट्स किसके साथ रह रहे हैं, ए, पेरेंट्स ने प्रॉपर्टी किसको दे दिया है, बी, दोनों बच्चे में से ज्यादा फाइनेंशियली अच्छा कौन कर रहा है, सी। ये बहुत सारी फैक्टर्स कोर्ट कंसीडर करके अकॉर्डिंगली ऑर्डर कर सकते हैं।
Sir, in India, the majority what I have seen or what could I find, suppose a couple have 5 children, and now the couple grown old, husband passed away, and there is a single woman is there, and what happened now? Single woman, she refused to give property to one son and ready to distribute among 4 sons. In this case, what this first son can do?
That will have to come under Hindu Succession Act.
Okay.
Discuss Hindu Succession Act, then we'll do that.
Okay, means still that first son can go and get the property, right, sir?
Depends. Many things there, whether it's ancestral property, whether it's an HUF property, whether it's a self-acquired property.
So in India, mostly 2 kinds of property we have seen. One's that parental property, जो क्या बोलते हैं इसे? I think forefathers' lands, I guess. Forefathers' lands, and the second one is the bought land, which is the name of the parents only. माँ बाप के नाम पे ही होता है mostly. This is what I have seen that.
वो बहुत layman classification है आजाद.
Right, sir.
This is not a lawyer's classification. That's
okay.
Lawyer's classification जो मैंने terminology use किया वो है.
All right, sir.
Ancestral, HUF.
Ancestors. I'm so sorry. Yeah, ancestors. Exactly correct.
ये जो है ना ये वो ancestral property किसी के नाम पे भी हो.
Right.
हम लोग हिंदू जब family law कभी करेंगे तो उसमें कभी देखना आपकी jointness of properties होती है. प्रॉपर्टी किसी नाम पे भी खरीदा जाए वो जॉइंट प्रॉपर्टी रहती है. So we'll deal with it at a different set provisions of law.
We'll do that. Thank you so much, sir.
सर एक और आप बता रहे थे जो मेंटेनेंस में ओल्ड पेरेंट्स के मेंटेनेंस में सीधे SDM को अगर क्लेम जाता है तो SDM के पास वो अथॉरिटी है कि वो सीधे मतलब उसको टेक एक्शन ले सकते हैं। तो मैं ये पूछ रहा था कि सर कि वो मैंने ओल्ड पेरेंट्स को केस लाने का जरूरत नहीं है, इसके लिए सीधे सीएम ही फाइनल डिसीजन दे सकते हैं।
एसडीएम फाइनल डिसीजन दे सकता है।
ओके सर, थैंक यू।
Good evening, sir.
Good evening.
I have a question. The Maintenance and Welfare of Parents and Senior Citizen Act, the petition has to be filed before the SDM only and not before the civil court.
Civil court has no jurisdiction.
Okay. And my next...
Yes, go ahead.
Next question is whether the application is to be filed through a lawyer or the person can file it by oneself.
Aggrieved person can file himself or herself. In fact, the presence of lawyer was barred by the act itself. It is only by judgments the lawyers are now permitted to appear. Lawyer की कोई role नहीं थी वहाँ पर.
And is there any prescribed format, or it could be in
any format? Even as it says that the tribunal can take suo motu cognizance, so one page can be sufficient enough.
Thanks a lot, sir.
So Rajesh, I think we have exhausted the questions.
And I think you must also be exhausted by now. It's more than 1.5 hours.
Oh my God!
It's almost It's almost 95 minutes now.
Oh my God! Let's close it. I thought today I thought I'll do less than 1 hour. Okay.
अच्छा, अन्य किसी को भी कोई प्रश्न है तो आप पूछ लिए, और एकदम से स्पष्ट तरीके से हिंदी में पूछें आप लोग।
उसमें कोई ऐतराज नहीं, आप हिंदी में तो पूछ सकते हैं।
सर मेरा एक क्वेश्चन है सर।
हाँ।
कि पत्नी हस्बैंड से डाइवोर्स ले चुकी है और वो मेंटेनेंस लेना चाहती है ताउम्र, और वो लिव इन रिलेशनशिप में रह रही है और मेंटेनेंस भी लेना चाहती है, तो क्या सर वो हमेशा लेते रहेगी?
Again, Azad, Mohammed, you have to hear my previous lecture.
Sir, I am sorry, sir.
125 ये बड़ी क्लियर है, 125 में भी बड़ी क्लियर है, हिंदू एडॉप्शन मेंटेनेंस एक्ट में भी बड़ी क्लियर है कि if a woman is living an unchaste life, तो वो मेंटेनेंस के लिए दावेदार नहीं है।
ओके सर।
गुड इवनिंग सर। सर अगर वो लिविंग में नहीं रह रही है उसके बाद का प्रोविजन सर क्या है?
अगर लिविंग में रिलेशनशिप में नहीं है तो फिर वो किसके अगेंस्ट क्लेम करेगी, किस लड़के के अगेंस्ट क्लेम करेगी?
अच्छा नहीं सर, जैसे वो शादी मतलब सर वो जैसे कि बोल रहे हैं वो उसका जैसे वाइफ है उसका डिवोर्स हो गया, तो उसका अगर वो फिर वो दूसरा शादी जब तक अगर वो नहीं करती है तब तक वो ले सकती है, वो इंटाइटल्ड है मेंटेनेंस लेने को।
सेक्शन 125 प्रोवाइड करता है डिवोर्स्ड वुमन।
ओके सर, थैंक यू सर।
पूरे जीवन ले सकती है मेंटेनेंस, अनचेस्ट जीवन नहीं जीना है उसको, मतलब।
ओके सर।
सर तो क्या दूसरी शादी के बाद भी ले सकती है वो?
नहीं। दूसरी शादी के बाद नहीं, वो तो फिर दूसरा हस्बैंड मेंटेन करेगा ना उसको। ठीक है। अन्य किसी व्यक्ति को कोई क्वेश्चन है तो पूछ लें, क्योंकि 90 मिनट से ज्यादा हो गया है तो सॉलिड पहुंचा दे संजीव जी को आज। जी
सवाल ये है सर कि अगर मेंटेनेंस अगर उसको दिया जा रहा है, कोर्ट ने जो भी तय की मेंटेनेंस, एक मिनट, अगर मेंटेनेंस से मेंटेनेंस आपको हर महीना देना है, अगर किसी कारण उस बीच में अगर मेंटेनेंस जो देने वाले व्यक्ति अगर स्रोत कम हो जाता है तो उस केस में सर किस तरीके से मतलब वो मेंटेनेंस जो अमाउंट तय किया गया वही अमाउंट देंगे कि कुछ पिटीशन वगैरह डालना पड़ेगा कोर्ट में कि हमारा इनकम स्रोत कम हो गया, हम आप थोड़ा सा हमारा नया जो भी लायबिलिटी है उसको थोड़ा सा देने के लिए सर काम करना होगा?
सब लॉ में ये प्रोविजन है चेंज ऑफ सर्कमस्टेंसेस। चेंज ऑफ सर्कमस्टेंसेस का मतलब है कि जो पहले सिचुएशन था वो अब नहीं, सर्कमस्टेंसेस वही नहीं है, या तो आपकी अर्निंग कम हो गई, या वाइफ की अर्निंग बढ़ गई, या वाइफ की रीमैरिज हो गई, व्हाटएवर, एनी चेंज ऑफ सर्कमस्टेंसेस आप कोर्ट जाके मॉडिफिकेशन मांग सकते हो उस ऑर्डर का।
सर तो इसका वाइस वर्सा भी है, वाइफ भी क्लेम कर सकती है आमदनी बढ़ने पर हो।
एग्जैक्टली, क्यों नहीं।
अच्छा सर, मेरा एक क्वेश्चन है, जैसे कोई मैरिड पर्सन है और उसकी वाइफ दूर रहती है बच्चे के साथ, वो आती नहीं है, तो अगर वो लिविंग रिलेशनशिप में किसी के साथ रहता है जस्ट फॉर प्लेजर, तो फिर वो लड़की एंटाइटल्ड है ये रिम्यूनरेशन के लिए?
कन्हैया जी, इस प्रश्न का जवाब दिया जा चुका है। आप उसी से समझिए इस बात को कि चेस्ट जब तक कि वो सही ढंग से सही कैरेक्टर के साथ सही मतलब आप समझ रहे हैं ना, वो चेस्ट का जो डेफिनेशन है एज अ लॉयर आप समझ जाइए, और जब तक वो रहेंगी तभी तक वो एंटाइटल्ड है मेंटेनेंस के लिए, अदरवाइज नहीं है। लेकिन ये भी तथ्य है कि केवल आरोप लगा दे कि कोई वो चेस्ट जीवन नहीं जी रही तो वो नहीं चलेगा, उसको कन्विक्ट करना पड़ेगा कि वो चेस्ट जीवन नहीं जी रही है।
ठीक है, थैंक यू सर।
अच्छा संजीव, वी आर सो थैंकफुल दैट यू हैव स्पेंट सो लॉन्ग अ टाइम, इतना देर तक लगातार बोलना और समझा करके बोलना और काफी स्लोली बोलना ताकि सब लोगों को समझ में आए। हम लोग सब बहुत ही ऑब्लाइज्ड हैं। और एज फार एज वो मुद्दा जो था कि लीगल एड का, हाँ, तो ये है कि हम लोग भी प्रेरित कर रहे हैं, और जब यंग लोग आएंगे सामने लीगल अवेयरनेस फैलाने के लिए और लीगल एड प्रोवाइड करने के लिए, तभी पॉसिबल है कि समाज में एक व्यापक पैमाने पे सुधार हो, व्यापक पैमाने पे मानवाधिकार जो है, ह्यूमन राइट्स जो है उसका वो बढ़े, और लोगों में खुशी का माहौल ज्यादा है। और इसमें हर लॉयर का बहुत ही बड़ा योगदान हो सकता है। और इसलिए आप इस बात को समझिए कि संजीव जी भी अपना समय निकाल रहे हैं, अभी क्लाइंट से मिलते या अपना कहीं करके रिलैक्स ही करते, और ये लीगल एड ही एक तरीके से प्रोवाइड कर रहे हैं और लीगल अवेयरनेस का काम कर रहे हैं। हालांकि ये लीगल अवेयरनेस इज मेंट फॉर लीगल एक्सपर्ट्स, जो कि आप लोग बडिंग लीगल एक्सपर्ट्स हैं, या कुछ तो काफी लोग तो बन भी चुके लॉयर। तो अब इसी क्रम में संजीव, हम लोग बहुत जल्द एक अन्य मुद्दा है ब्लैकमेल का, जो लड़कियां इधर फेस करती हैं। काफी इधर क्या मतलब व्यापक पैमाने पे हमारे देश में ऐसा अपराध होता है कि इंफॉर्मेशन टेक्नोलॉजी के डिवाइसेस को यूज करके या चिट्ठी पत्री को यूज करके और लड़कियों को जो है ब्लैकमेल किया जाता है, उनसे पैसे वसूले जाते हैं या अन्य अनैतिक कार्य करवाए जाते हैं। तो उस पे वी आर ट्राइंग टू, हम लोग एक प्रयास कर रहे हैं एक जागरूकता अभियान का या जागरूकता का फैलाने का, कि उससे संबंधित प्रावधान क्या है, ताकि सभी लॉयर्स ये चीज जाने और लॉ स्टूडेंट्स ये जाने और अपने से आगे बढ़ा सके, ताकि हम लोग जो पाए कि मोस्ट ऑफ द गर्ल्स जो हैं वो इस बारे में कंप्लेन करने से भी कतराती हैं, ये सोच करके कि कुछ ऐसा भी चीज है उसमें कि हम खुद ही फोटो खिंचवा लिए थे, या फोटो तो आ गया भले ही वो मैनिपुलेटेड फोटो हो, तो कहीं कोर्ट हम ही को गलत ना समझ ले, जबकि ऐसा प्रावधान वहां पे है कि कोर्ट ऐसे एविडेंसेस को एक्सेप्ट ही नहीं करता।
राजेश पूरा कवर हो जाता है इंफॉर्मेशन टेक्नोलॉजी एक्ट में, अगर हम लोग कभी करेंगे सेशन तो देख लेंगे, उसमें काफी कवर हो जाता है।
राइट।
और डेफिनेटली आईपीसी में भी सेक्शन 354 एंड ऑल हैव बीन मॉडिफाइड, तो इस इश्यूज को आंसर करते हैं वहां पर हम लोग।
हाँ, तो वो है इंडिसेंट रिप्रेजेंटेशन ऑफ वुमेन एक्ट है, ट्रैफिक एक्ट है, तो इन सबों को मिला करके वो ब्लैकमेल पे खास करके एक सेशन हम लोग जरूर करना चाह रहे हैं। तो we'll request your cooperation in that on that issue also.
Sure, Rajesh.
अच्छा, तो should we say now bye bye to each other, all
yes.
of us?
Thank you so much.
Thank you so much, sir.
Thank you so much, sir.
Thank you, sir.
Thank you, sir.
Thank you.
Good night, sir.
Thank you, sir.
Okay.
Thank
Bye.
राजेश सर,
And on behalf of all,
धन्यवाद
thanking
सर।
you, Sanjeev. Thank you.
Thank
Bye,
you,
bye,
Rajesh,
bye, bye.
for organizing a wonderful show. Actually, you're putting a lot of effort. We don't thank you, but actually we all should thank Rajesh. Pandey, for making this
it's such a
event.
pleasure for me. Opportunity for me.
जी सर, एक और चीज बोल रहे थे संजीव सर से कि अगर कभी मिलेगा तो सर दहेज वाला इशू पर भी एक सेशन रखिएगा कि दहेज प्रताड़ना का मैक्सिमम केसेस फॉल्स आते हैं।
ठीक है,
मैं मैक्सिमम तो नहीं बोलूँ, लेकिन केसेस ऐसे फॉल्स आते हैं, तो उस पर कैसे आगे बढ़े?
कौन से इशू पे कह रहे हैं निरंजन जी?
दहेज प्रताड़ना,
दहेज प्रथा पे
सर, डाउरी एक्ट,
दहेज प्रथा।
जी
ओके ओके
सर हफ्ता में सर एक दिन कम से कम सर आप लोग समय दीजिए सर हम लोग को, ताकि हम लोग कुछ सीख सके आप लोगों से।
नहीं, हम लोग का तो बहुत ही मन है, लेकिन हमको नहीं लगता है कि संजीव जी इस सप्ताह में एक दिन दे पाएंगे। हम लोग तो काफी प्रयास कर रहे हैं, संजीव जी के लिए तो इम्पॉसिबल ही है। लेकिन
15 दिन में कम से कम एक दिन देने के लिए, 15 दिन में एक दिन कम से कम,
एटलीस्ट 1 मंथ में भी 1 क्लास रहेगा।
नहीं 15 दिन में एक दिन, दैट्स अ प्रॉमिस, विल डू इट। अभी तो टाइमिंग हम लोग कर सकते हैं, उसके बाद बात देखेंगे, बट अभी तो लोग कर सकते हैं।
ग्रेट, ठीक है, दैट विल बी ग्रेट।
हाँ आप लोग हम इंतजार करेंगे आपका सर।
ये भी ठीक है, तो हम लोग अगर रेगुलरली हम लोग करें तो ज्यादा अच्छा है, तो ज्यादा स्टेप में भी कर पाएंगे।
ठीक है,
ओके, थैंक यू ऑल फॉर ज्वाइनिंग, एंड थैंक यू संजीव अगेन।
थैंक यू,
बाय बाय।
थैंक यू।